Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled William Donovan versus Sarah Teel, case number 24AP316. Appellant William Donovan is self-represented and appearing via phone. Appellee Sarah Teel is self-represented and not present for oral argument.
All right, and we understand that she has also not filed a brief in connection with this matter. Mr. Donovan, are you able to hear me, sir?
Not very well, but it's what we've got.
All right. Please identify yourself by stating your name on the record. Then you may proceed with your argument. You have 5 minutes, sir. And when that time is up, I will notify you.
Thank you. May it please the court, William Donovan appearing pro se. This case is appealed from the lower court's denial of a motion for a new trial. This appeal focuses on two due process questions. Here we present two constitutional issues of procedural due process. One, the right to be heard, and two, the right to have all relevant evidence considered. These two questions were not adequately addressed in the court's entry regarding motion. In question one, the transcript of the hearing is the factual basis directly demonstrating the denial of due process and the plaintiff's right to present his case in chief, constituting a fundamental violation of due process. This denial effectively nullifies the proceedings. The right to testify, call witnesses, introduce evidence, and make an argument are exclusions without which a claim cannot otherwise be proven. Thus, question one is not just a denial of due process, it is also a denial of due process and a deprivation of a protected interest, the statutory protection of an RFA order. This claim is supported in Matthews v. Eldridge, Armstrong v. Manzo, and Mullane v. Central Hanover Bank, and supported in Vermont by Brault v. Town of Milton, where the court's function is to assure that no party will be deprived of property without satisfying the fundamentals of due process, and in Vermont through Scheindet versus Cambion Group, a small claims appeal directed at the right to testify, court interruptions, improper closing of evidence, and improper procedures and analysis and findings used by the court. Question two is the court's failure to consider all relevant evidence. Specifically, the court failed to consider document A2 found in the appeal volume 114, which is conspicuously found in the exhibits list at AV 119, and which was properly submitted and entered into the record by the judge. This evidence, which is central to the strategy to meet the burden of proof, is a confession to sexual assault and to lewd and lascivious conduct, both of which individually meet the statutory definition of abuse. While the hearing transcripts record the judge as saying, quote, the court needs to make a finding that the defendant abused as defined by statute, the court is unable to make that determination today, unquote. However, under the standard of preponderance of the evidence, the propellant's brief demonstrated that when 3252 is applied to the facts of the defendant's confession in document A2, the elements are indeed met for sexual assault, which fulfills one of two requirements for the issuance of the RFA. The other requirement is danger of further abuse. Vermont statute provides that the court shall issue RFA orders with a finding that a defendant has abused the plaintiff and that there is danger of further abuse. Despite the court's findings that there has not been any evidence presented to show a danger of future abuse, existing evidence in the record directly contradicts the court findings and demonstrates sufficient evidence for finding a danger of further abuse. In Woodward v. Woodward, the court held any relief sought depends on plaintiff's reasonableness of fear and not the defendant's intent. And in Washburn v. Folks, in settling a minimum standard that these circumstances surpass, the court held, we need not find a pattern of behavior such as frequent unnecessary contact to support a finding of danger of future abuse. Rather, it is reasonably inferred on the basis of the parties' relationship or a single instance or the absence of physical abuse or a variety of other grounds. In my situation, significant stalking behaviors enumerated in the exhibit list for document group B found at AV 117 and 118 demonstrates behaviors. Pardon me, is that 1 minute?
Yes, it was.
Okay. Demonstrates behaviors by the defendant exceeding those set forth in Washburn. Court transcripts show that the judge claimed that there is no evidence of ongoing unwanted contact, which is contradicted in the plaintiff's complaint affidavit, where it is stated that the defendant violated a written no contact request 9 times and made 4 appearances to his workplace in the months just preceding the RFA request. The court stated that, quote, no evidence was presented that shows there was a danger of further abuse, unquote. The testimony of the complaint affidavit also swears to a no contact violation by the defendant after a 6-month separation, which was broken due to her self-described mental health complications. The plaintiff respectfully asks that the court reverse and render finding in his favor on the issuance of the RFA based on a showing that the evidence fully existed in the lower court record to meet the statutory requirements for the issuance of the order, and which state statute requires to be issued upon that demonstration. The RFA can be issued under the terms requested in the appellate brief. Alternatively, the plaintiff requests that the court to reverse and remand back to the Superior Court under the finding that the lower court violated the plaintiff's due process rights, requiring a new trial under a different judge. Thank you.
All right, thank you, sir. Your time has expired. Bailiff may call the conclusion of the case, please.